first case on our calendar, Franz Coutard versus Municipal Credit Union. Thank you. You may begin.
Your Honors, good morning. May it please the Court, my name is Mr. Abdul Hassan. I'm the counsel for the plaintiff appellant Franz Coutard. Your Honor, the District Court granted the defendant summary judgment by finding an absence of the notice element of plaintiff's FMLA claim. I would say, Your Honor, we have 4 issues, the resolution of any of which would warrant the reversal of the District Court. But as to the first one, when the plaintiff told me, Your Honor, that he had requested leave, FMLA leave, to care for his grandfather, who was hospitalized, in and out of the hospital, first thing I said, what a good young man this is. The second thing was, gee, the FMLA may apply to this request under the in loco parentis exception.
Isn't that kind of the question? I mean, why didn't he just say, it's my grandfather, he takes care of me, and then we wouldn't be here? Right?
Because he did not know of the in loco parentis exception, and the defendant also did not know of the in loco parentis exception. It's one of those obscure exemptions.
Is it your argument that the defendant had a duty to inquire about the relationship between Mr. Coutard and his grandfather?
Yes, Your Honor, because it would take, if you know the big ghost in the room here is whether or not the defendant knew of the in loco parentis exception. If you tell a jury that that defendant should have known of the provision, it's logical to expect them then to inquire, like I did. It took me 5 seconds to figure this out. I'm not clairvoyant. I don't have a crystal ball. I'm not an FMLA genius. But if you know that the FMLA covers in loco parentis relationship, and the most common of which is dealt with in the regulations and all the literature from the Department of Labor, is the grandparent relationship, which is, by the way, is very common in the country. That's why Congress created this exception. If you know of the exception, it's hard to argue that you should not inquire or that you can't make the connection.
What was the actual response to his request?
Grandfathers are not covered by the FMLA.
Categorical statement that grandfathers are not covered.
Yes, Your Honor. No exception, no qualification. And I note that in the briefs, when defense counsels state the law, they do include qualifications such as generally, as a matter of course, or something like that. I pointed it out in the brief. And even if the statement was technically accurate, it could still mislead the plaintiff. And I would note, Your Honor, this provision is so obscure, and the knowledge of it by the employer and employee is so rare that the Department of Labor itself put out an opinion sua sponte, addressing the situation and trying to educate the employers about it. But
this was after the fact, not before the fact?
This was before, Your Honor. I think some couple years ago they did this.
Before your client took leave?
Yes, and it was educate employers who didn't understand how to deal with requests dealing with in loco parentis relationships. But I think we come back to the main question. If you know of the provision, I mean, think about yourselves. If you know of this provision and somebody tells you they need FMLA and they mention the word FMLA, I think that's a key distinction here. If he didn't mention the FMLA, even though he wasn't required to, the defendant would have a stronger argument. When I say to someone is an employer under the FLSA, for example, or the FMLA, it's a loaded term. You know that they have more than 50 employees. You know that they operate within a certain radius. You know all the things required for that term to apply would trigger that conclusion. And here we were dealing with what is called an FMLA specialist. If we were dealing with the hot dog vendor in the corner, it would be a different story. He doesn't know the FMLA. But an FMLA is about...
Have that many employees either.
You're absolutely right, Your Honor. And so a jury has to look at who the person is. It's an FMLA specialist. Moreover, the employer is charged with knowledge of the statute. Even more so when you're a large employer with an FMLA specialist, a legal team, etc., etc. The question, it turned out the employer did not know of this provision. When I asked Ms. Nikki, have you ever heard about it? She said, I probably heard of the in loco word, didn't even know the name. And there's nothing wrong with that. I mean, it's an obscure provision in the law. But the effect of it is they could not, they give the client wrong information, and they could not perform their duty, which is to make the connection that the FMLA may apply to the leave request. And that's pretty...
Is the employer charged with knowing all the rules?
Yes, Your Honor. You'll presume, whether it's practical or not, just like I'm charged with knowing the law, the employer is charged with knowing the entire FMLA because they have to apply it. And they have to...
What's your authority for that?
Well, the statute itself, Your Honor, it says that when the person makes the request, the employer has to process the request under the... And it says that the employee doesn't even have to mention the FMLA, and it puts that burden on the employer to determine whether the FMLA applies. So in order to perform that function, the employer has to know, and I can follow up with some cases, Your Honor, afterwards if you still need some additional authority. Your Honor, in addition to that, and by the way, I think there was some difference in the regulations that the district court relied on and what the current regulations are. The prior regulations require that you state the reasons to determine if the FMLA applies. The new regulations state sufficient information to reasonably determine if it may apply. Very, very different regulation, the type of thing that a jury is well suited for. Also, the regulations state that you have to show that the plaintiff had actual notice of this requirement. To the extent the court found this was a requirement that he had to mention in loco parentis. And let's be honest, how in God's name is an employee going to know what in loco parentis is? I mean, most lawyers don't even know what that is, right? I only learned about it a couple years ago, and I've been doing this for a lot of years.
Hassan, your time is
Thank you, Your Honor.
expired. You have reserved some minutes for rebuttal. We'll hear from Municipal Credit Union.
Good morning, Your Honor. Good morning. May it please the Court. Douglas Motzenbacher, Gordon & Reese, New York, for Defendant, Appellee, Municipal Credit Union. Your Honors, we urge that the Court affirm the judgment below. The judgment below is exactly right.
You deny that the employer had a duty to know the rules and apply them correctly?
Oh, absolutely. They have an obligation to know the law. Here, though, below we had an interference claim. That's what this case is, and that's what he presses on appeal. To have an interference claim, you have to show you have a right to take leave. You don't have a right to take leave until you confer enough information upon the employer as to the employee's circumstances.
He said, I want FMLA leave to care for my grandfather.
Right.
Was that not enough information to trigger the employer's duty to look at the rules and ask him, did your grandfather take care of you?
No, every court to consider that question, Your Honor, has ruled no. And plaintiff appellant cites not a single case that goes his way on that issue. There has been a line of authority that we cited below and cite here that comes from the Sherrod versus Philadelphia gas case from the Third Circuit. That's been followed by easily 6 district courts that take the same position, that the ball is in the employee's court. The onus is on the employee to come forth to give the employer sufficient information that the employer can make.
What was the
informed? It's called Sherrod. It's an unpublished opinion. It's cited in my brief.
Okay. I got it.
H-E-R-R-O-D.
Is there any dispute as to what your client's response was? Was it categorically grandfathers are not covered?
Yes, it was just I'd like to take leave from my grandfather. Well, I don't think grandfathers are covered. That's the beginning and end of the conversation.
I'm sorry. When did the statute change?
I think sometime in the regulation has changed, Your Honor. The regulation changed, but the substance of the regulation, and I wanted to get to this, is the same.
When did it change?
I think 2009 or something in there.
Sherrod was 2003.
Absolutely correct. But the current rule, it just says it's still both the prior version and the current version each put the onus on the employee to say.
Are there any cases that do that after the change in the language of the regulations?
I found one yesterday. It's from Noel Hillman in the United States District Court for the District of New Jersey. It was a late 2015 case, Your Honor, that holds that where Judge Hillman cited the Third Circuit decision in Sherrod and ruled this exact same way. I can submit a letter following argument, but as to the citation, but I did find one case. It has not. The Third Circuit has not, contrary to plaintiff's argument, overruled the case, or they've never even alluded to it. As of yesterday, shepherdizing the case, I found not a single Third Circuit case that even where the Third Circuit cites or goes back to the case. The district courts have applied it. It stands for two different principles.
I see it's an unpublished opinion. Does that make it under the Third Circuit? We know our rules, but does that make it non-precedential?
I believe that's correct there too, Judge, but it's been cited as persuasive and followed as a reliable statement of the law. And I suppose when we're told when the Supreme Court or the Court of Appeals, even in dicta, specifically addresses an issue, the lower courts are supposed to give that some consideration, I believe.
Whether we are a lower court in the Third Circuit is a fair question.
Well, no, I'm saying in the Third, it would just be merely persuasive. I'm talking about the U.S. Supreme Court or, the courts, the district court level. But there's not a single case in his brief that goes his way, and we've cited about 7 that go ours. The regulations clearly, prior and current versions, put the onus on the employee to disclose that.
And what was the difference between the old and the new regulation? The word may?
It says an employee giving notice, and this is the superseded regulation reads, an employee giving notice of the need for unpaid FMLA leave must explain the reasons for the needed leave so as to allow the employer to determine that the leave qualifies under the Act.
Is that quite different from the way it works
now? It says an employee shall provide, whereas it was saying before may.
Whether the employer reasonably determined whether the FMLA may apply.
Determine whether it may apply. Oh, yes, but I'd say.
Well, that's different from whether it can determine that it does apply.
Well, yes. At the same time, Your Honor, my client gave the exactly correct answer. It's grandparents, nephews, next-door neighbors are all in the same non-protected class. You can't exercise a protected right to those people. There's no special rule for grandparents, none that we found.
Unless they served in loco parentis to the claimant.
Right. And that we believe, Your Honor, and we submit that the case law on this issue has put the onus on the employee to at least elaborate and then to get the ball into the employer's court such that then the employer asks and makes it.
Counsel, isn't the adequacy of the notice a fact question that shouldn't be decided on summary judgment in any event?
Really not. Where it's here, the issue was presented. The record was all but stipulated in terms of what the parties said.
It's the adequacy of what the parties say. I think everyone agrees on the language, but looking at the language and then looking at the statute and regulations, that is a question of fact, whether it was enough to trigger the employer's duty to ask whether this person was in loco parentis.
If that were the holding today, this would be the first court that I know that would arrive at that conclusion. So one other issue, Judge, was another issue below, and I don't want to dwell on it, has to do with whether the plaintiff presented sufficient evidence that his grandfather had a serious medical condition. There were no expert reports in the litigation. There was no medical certification. There was simply a discharge summary from an emergency room. And one thing you heard earlier, that the plaintiff's grandfather was hospitalized. That's not true. The plaintiff's grandfather was taken to the emergency room. He waited, I'm sure, a good long time. He was seen, prescribed some albuterol, and I believe a second medication, and discharged, sent home. There is no suggestion here that he was going. The doctors don't say that someone must be with Mr. Dumond, the grandfather, going forward. There's nothing that says that he has to be in the care of a third person immediately. No one can, and there's certainly nothing in the discharge summary, let alone we don't have a certification or an affidavit or expert report that's been presented in this court. And certainly MCU, had we been just at the employer-employee level, would have been entitled under the statute, under the regulations, to request a certification as to the severity of his grandfather's condition and whether that requires, whether Mr. Coutard is going to be required to assist the grandfather. With that, Your Honor, it was, this case was, we had offered to rehire him if he could confirm. This is 2 months after he filed his complaint. We had offered to rehire him if he would confirm the in loco parentis circumstance. The district court noted it, and he refused to even respond. At the initial conference before Magistrate Judge Scanlon, plaintiff's counsel said, this request, it's all bad faith. So we called his bluff, and he blinked. And now he chose litigation. He says as a complaint he demands reinstatement. Well, we served up an opportunity for reinstatement on a platter, and it was just turned down. Someone just choosing litigation over resolution, certainly, Your Honor, it's difficult to credit the good faith of that. Your Honor, I have 52 seconds left if I could save that.
Thank you.
Thank you, Your Honor.
Mr. Hassan?
Yes, Your Honor. In terms of whether or not adequacy of notice is generally an issue of fact, I think the district court itself on page 14 cited several cases and noted that it is generally an issue of fact. The special appendix on page 14. So it is generally an issue of fact. And if you account for the change in the regulation, which use classic jury type language, sufficiency, reasonableness, and so on, and may, as opposed to must, it's definitely a jury question, Judge. Your Honor, in terms of the serious health condition issue, I think the argument is not that he didn't have a serious health condition, but that we needed expert witnesses to present that. As the case itself that counsel cites, the Shar case, in that case the Third Circuit noted that every court of appeals to consider the issue has held that lay testimony is enough to defeat summary judgment on
What was the health concern?
The plaintiff's grandfather suffered a stroke 3 years ago and has been incapacitated ever since. He's in his 80s. He also has diabetes, high blood pressure, heart disease, which means that any little thing like a cold or bronchitis for him is a serious, serious matter. So he, under the FMLA has objected. Is that
what he communicated to his employer?
He told the employer that his grandfather was in the hospital and very ill. I don't think he mentioned the stroke or anything like that. But an overnight stay in a hospital is considered by definition a serious health condition. And in that Lichtenstein case I cited, the Third Circuit said, in fact, you tell them that you're in a hospital, since that's usually covered, it's enough to trigger for the notice, inquiry notice. Also, Your Honor, the Sharad case, all of the lower court, it's an unpublished disposition, which means it doesn't even have precedential value in the Third Circuit. All of the district court decisions that counsel cites, whether before or after the regulations, cite the Sharad case without distinguishing the change in the regulations. This court would be the first. I think this is an issue of first impression for this court. So the Sharad case is not persuasive because it doesn't account for the difference in regulation, and it also doesn't account for, I think, common sense. How is an employee to know about the in loco parentis exception?
You concede that your employee, your client, was offered his job back?
No, Your Honor. Let me address that, Your Honor. We had lots of discussions. We told Mr. Matzenbecker, my client wants to come back. Mr. Matzenbecker was fishing to create a mitigation of damages defense. I said, okay, I'll send him back. The magistrate told Mr. Matzenbecker, why don't you just, it was 4 months into the case, why didn't you just reinstate the guy and cut off the damages. Mr. Masabecker said, we have a right to this information and we will insist on it. When they did get the information, through the best means possible, the depositions a few months later. By the way, I did tell them that we gave them all the information. They wanted an affidavit form, this form, that form. But Mr. Masabecker, when we did give them the information.
Any of this in the record? I mean, I asked the question, you're answering me, but is any of this in the record? The whole question about that, the facts that you are now describing, are they in the record? Again, I can understand if they wouldn't be, and you're answering my question, but I want to know if they're.
Your Honor, some of it probably is, but we objected to settlement discussions being part of the evidence under Rule 408, as well as this court's precedent.
Thank you.
Thank you, Your Honor.
Time has expired. Thank you both. We'll reserve decision.